All right, here we go again. It is Thursday. And I got to say something right off the bat, is I'm always shocked that anybody even shows up for this stuff, because I know how difficult it is. I mean, I look at it, and it's difficult for me to even try to consider, starting from scratch, 5 weeks ago or 4 weeks ago. Wow, I can't even imagine, how scary that is. But tonight's I had sort of an epiphany. Last night I went through Article 1 of the cultural property pretty deep. And I was going to go and finish up Article 1 again by taking out some of the terms that I thought were out of control interesting. I mean, seriously, I'm looking at these words and I'm thinking, wow, rare collections. In fact, why don't I just have a little bit of fun up front before I get into what tonight is all about. Tonight is closing the door. I'm going to close the door. I'm actually going to prove everything tonight. And next week we're going to go over my documents. We're going to go over all the reasons why I did what I did and what I did. But tonight I'm going to close the door. I'm going to take everything that I've been covering the last 4 weeks, and I'm going to put it all into one little package, one little beautiful Christ Mass package. And I'm going to show you something tonight that if it finally sinks in, you're going to realize that everything going on wrong in the world today is built upon an idea. An idea, just a really simple idea. And all we have to do is, well, I'll get to that. This isn't a cliffhanger, people. By the end of the night, you're going to know what's going on. So anyway, let's see. Back to Article 1 real quick of the cultural property. It's important to know cultural property. Why? Because what's cultural is not yours. What's cultural is not yours. It's shared. It's shared by everyone. In other words, Illinois is a culture. Winnebago County is a culture. The church that I grew up in is a culture. All these subgroups and ideas and collectives and things like that, they're all cultures. I mean, even the health club I go to is a culture, because I have to join it. I have to accept it. I have to share. I mean, do you realize that the health club I go to pretty much every day, I get on a machine or whatever, and there are probably, 1, 2, 3, maybe 4 dispensaries around the health club where they have little wet wipes. And every time you get done using a machine, you're supposed to wipe it down. In other words, to protect the other members, you're supposed to clean up your mess. Now, when I was growing up in the health clubs, a bunch of guys were swearing and screaming and lifting a bunch of weights and sweating all over the place, and it smelled like all get out. There was no cleaning up anywhere at that point. I mean, it smelled like a gym. But now, again, in the ages of the people in my health club, my God, it goes from probably, mid-teens to 80s plus. It wasn't like that when I was growing up. So my point is that all of these are cultures. And the shared space, the shared ideas is exactly that. It's a sharing. And that's what's important to understand is that, again, whether it's my health club, whether it's Illinois, whether it's the United States, they're all considered cultures. And the property and the rights within these cultures are not singular. They're communal. So the only thing you have to really learn is there is your stuff, and then there is everyone else's. I don't care about everyone else's stuff. I don't want anything to do with your stuff. I'll be honest with you. I don't want to be responsible for it. I don't want it in my hands. I don't want to hold on to it. I don't want to be told that I have to help protect it. I don't want anything to do with your property or your rights. I don't. Because that places a burden upon me that I'm not really willing to carry. I got enough of my own problems. So the idea is this. Your property, which is industrial property, private industrial property, is your stuff, your capital and labor and your genetic product. That's you. That's yours. Cultural property is shared property with shared rights. And if it's shared, it's not yours. And like I've been telling you all the way up to this point here is that the afterbirth material goes one of two directions. When you claim your stuff, it pulls into you and you become the age of majority. And like the Wk5 says, when a man proves life, he's revested with his title. When you do what's necessary, you get your stuff in your life. If you don't, just like in Haslam versus Lockwood, when that afterbirth falls to the ground, it becomes part of the community. And now the afterbirth material is community property or cultural property. And that's the problem. So that's where we're gonna end up there. But let's just look over this article one last time, because I went really deep into the first paragraph, and now I just want to go through these A through J again real quick before I get into the tonight's material. So again, Article 1 says, for the purposes of this convention, the term cultural property means property which, on religious or secular grounds, remember, there it is right there, there's your DNA, on religious or secular grounds, it doesn't matter, is specifically designated by each state as being of importance for archaeology, prehistory, history, literature, art, or science, and which belongs to the following categories. We went over those last night, so here we go. A, rare collections and specimens of fauna, flora, minerals, and anatomy, and objects of paleontological interest. Again, if you don't know these words, look them up. I'm not going to do that tonight. B, property relating to history, including history of science and technology and military and social history. Military history, social history. Remember that the birth record itself is what? An issue of national security. An issue of national security. Social history. That could be politics. It goes on to say, to the life of national leaders, thinkers, scientists, and artists, and to events of national importance. Do you think that the birth record, because it's the national security issue, in other words, the thing that guarantees payment of all the activities that are going on in the government, do you think that maybe that event, your birth event, is of national importance? When FDR consecrated the nation and made this ground holy ground, do you think that maybe that is of national importance? That's the birth record. C, products of archaeological excavations, including regular and clandestine, or of archaeological discoveries. Again, I find it funny that in the courtroom they use the word discovery. I know why. They're digging into the past to see what's available for them to use. D, elements of artistic or historical monuments or archaeological sites which have been dismembered. Man, that's a tough one. A monument or archaeological site, a monument, a site, a monumental site which has been dismembered. Dismembered. That's a strange word to me to be used there. E, antiquities more than 100 years old, such as inscriptions, coins, and engraved seals. Isn't it funny? engraved seals. I know what everybody's thinking, what an engraved seal is. But you got to think way outside the box, something that has been engraved or placed within a grave. F, objects of ethnological interest. G, property of artistic interest. In other words, literary compositions, books. Again, it falls under the Copyright Act of 1790. Property of artistic interest, such as pictures, paintings, drawings produced entirely by hand on any support and in any material, excluding industrial designs and manufactured articles decorated by hand. Original works of statuary art and sculpture in any material. Original engravings, prints, lithographs, original artistic assemblages, and montages in any material. In other words, just by putting things together. Rare manuscripts. Does anybody know what a manuscript is? And incunabula, whatever that is. I never did look that up. Old books, documents, and publications of special interest. Historical, artistic, scientific, literary, singly or in collections. Have you ever had anything gone to collection? Postage, revenue, and similar stamps, singly or in collections. Isn't that funny? Or in collections. Archives, including sound, photographic, and cinematographic archives. Let's see, does it go on to anything else? Okay, articles of furniture more than 100 years old and old musical instruments. Okay, that's it. I'm not going to go over that. I think that, again, if you're extremely interested in what this property is, go in there, bust out your Black's Law, have the online Webster's available, and start looking at these words. You think you know what they mean? You really don't. None of us do. I mean, until you start looking into it, you don't know what they're trying. Well, they're not even trying to say it. They are saying it. So anyway, I sent out for tonight, it says trust, common law, and the IRC, Internal Revenue Code 501c3 and 4947. We're going to go through this paper tonight. Yeah, Kurt, I don't want to deal with the IRC. Look what it says here. It says trust, common law, and the IRC. It's almost like it doesn't even make sense to me. Those two should not even be in the same sentence as far as I'm concerned. So here we go. Again, just remember those two different segments, those two different positions, your property and community property. Your property and community property, the maternal afterbirth, when it drops to the ground, nobody claims it. Haslam versus Lockwood, first week, it falls onto the ground of the community, onto the ground, the fee, F-E-E, of the community. It becomes community property. There you go. Okay, so here we go. I'm on page where it says Basic Legal Rules Regarding Trusts and IRC. Introduction. The following Q&As discuss basic definitions, distinctions, and rules regarding trusts and Internal Revenue Code 501c3. You know what that is. Those are the charitable or churches or whatever. Much of this discussion focuses on state common law concepts regarding trusts. Bullet point 1. State law creates legal interests and rights. Federal tax law designates what interests or rights so created shall be taxed. Look at this very first sentence. State law creates legal interests and rights. Creates. State law creates legal interests and rights. Federal tax law designates what interests or rights so created shall be taxed. It already tells you, right off the bat, state law creates legal interests and rights. What does that have to do with you? What does it have to do with your property? Private property. What is private property? Let's get this out right now. Is private property taxable? Oh, I bet a lot of you don't know that it's not. Private property is not taxable. Private property is not taxable. If that's true, and it is, by the way, then how can your labor be taxed? If private property is not taxable, and it's not, how can your house be taxed? How can there be a real estate tax? Because it's not private. There's your answer, people. How can your labor be taxed if private property is not taxable? Because your labor is not private. State law creates legal interests and rights. I'm going to go to the word interests right now in blacks, page 729. 729, black. 729. Interests, in its most general term, that can be employed to denote a right, claim, title, or legal share in something. Interest, the most general term that can be employed to denote a right, claim, title, or legal share in something. A legal share. In its application to lands or things real, it is frequently used in connection with the terms estate, right, and title. More particularly, it means a right to have the advantage accruing from anything. Any right in the nature of property, but less than title. Isn't that odd? Any right in the nature of property, but less than title. In other words, if there's an interest, then both the property and the title can't be in one place. How strange is that? It says the word interest is used throughout the restatement of Thurs to denote the object of any human desire. So interest is about the object itself. So I'm going to go to the word object because that's page 967. 967. Object. Here it is. Object. End aimed at. The thing sought to be accomplished. The aim or purpose, the thing sought to be attained. The thing sought to be attained. Again, keep your head where it belongs. The thing sought to be attained. The object. I'm looking. It says because this is so specific, and it says the thing sought to be attained. I'm going to go to the word thing. Now we covered a little bit of that last night, but not in Black's Law like this. So 1326 is thing. 1326. Okay. Thing. Things. The objects of dominion or property as contradistinguished from persons. The object of a right, i.e., whatever is treated by the law as the object over which one person exercises a right, and with reference to another person lies under a duty. Again, they're talking about an object that gives rise, a thing, an object, something real. It says up at the top there, such permanent objects not being persons are sensible or perceptible through the senses. Things are distributed into three kinds: things real or movable, comprehending lands, tenements, and hereditaments. 2, things personal or movable, comprehending goods and chattels. And 3, things mixed, partaking in the characteristics of the two former as a title, deed, or a term of years. Remember the word mixed. I went over that, I believe, in the last couple of days. An adulteration is something mixed. So 3, things mixed, partaking in the characteristics of the two former as a title deed. Look at that. Number 1 is things real or immovable, comprehending lands, tenements, and hereditaments. 2, things personal or movable, comprehending goods and chattels. Remember way back when I was talking about real estate? And real estate, in order for it to be called real estate, that would be where the house is actually attached or founded upon the land itself. It's tied to. It's still part of the land. The house and the land are one. That's what they're talking about right here. It says, things mixed, partaking in the characteristics of the two former, meaning things real, in other words, the land, and things personal, which is the goods or the chattels, which is the name. Father's name is the house. The DNA is the land. They need to be together to be considered as real estate. And it says things mixed, partaking in the characteristics of the two former as a title, deed. Title, deed. Title is the name. The deed is to the land. That's a split. They just created two positions. If they're not bound together as one single unit, they're going to be treated separately. And remember, all trusts require two separate positions. If I own the house and the land, there is no trust. By the way, I guarantee everything going on in that courtroom is about a trust. Everything. Next bullet point says, the law in any particular state may differ from a general rule discussed below, so it may sometimes be necessary to refer to the law in the particular state involved. There is no uniform or model law of trusts adopted by most states, although a few uniform laws relating to certain aspects of trusts have been widely adopted. I always think of the word, when I hear the word adopted, I always think of that state creation, that the child of the state has been adopted by you or me. Okay, so here we go. By the way, I mean, this is obviously by Ward L. Thomas and Leonard J. Henske Jr. I'm sure they're both attorneys or tax attorneys or whatever. So what is a trust? It says kind of organization. Trusts are one of the major forms of organization for federal tax purposes, along with corporations, partnerships, and governmental units. By the way, which one are you? If you're after some trust property, which one of these four are you? Are you an organization? Are you a corporation, partnership, or governmental unit? Which one are you? If you want to go after this trust property, which one are you claiming to be? And by the way, it says trusts are one of the major forms of organization for federal tax purposes. So apparently, it is your intent to fall within taxpayer headings. So anyway, organization, page 991. Trusts are one of the major forms of organization for federal tax purposes, along with corporations, partnerships, and general or governmental units. Page 991, we're going to go to the word organization. I hope everybody's starting to see that you got to be a complete lunatic to agree to some of these terms. 991. They are laughing at us. I got to tell you that right now. 991. Okay. Organization. An organization includes a corporation, government or governmental subdivision or agency, business trust, estate, trust, partnership, or association, two or more persons. Two or more persons. So how many of you exist? Now, my wife would say, because of my schizophrenia, that there's way more than two of me. But it says two or more. Two or more persons having a joint or common interest or any other legal or commercial entity. How many persons have a legitimate claim on your life? Because in order for it to be an organization, it has to be two or more. And of course, it says kind of organization. Trusts are one of the major forms of organization for federal tax purposes, along with corporations, partnerships, and governmental units. So organization, corporation, partnership, and governmental unit is the potential trust. Organization, well, are you a corporation? Are you a corporation? How about this? Are you a partnership? Are you a partnership? Or are you a governmental unit? Okay, so you're none of those three? Then you must be an organization. If you're dealing with a trust, you have to be one of these four. Kurt, just said it came by. Screw that. A living man don't deal with trusts. Sole ownership in your life, there is no trust. And my God, they're telling you all over the place. Organization includes a corporation, government, or governmental subdivision or agency, a business trust, estate, trust, partnership, or association, two or more persons having a joint or common interest, or any other legal, commercial entity. Which one of those is you? Because it has to be somewhere in the word organization. Because the other would be a corporation, partnership, or governmental unit. So which one are you? You want to deal with the trust. You want to keep talking trusts. You want to keep talking about the Wk5 or Wk5. You want to keep claiming that shit, then which one of these four are you? If you go back to the afterbirth, now you're going to start to see some potential. Because it's possible. If you allow the afterbirth to actually exist as it is, I guarantee there's already a trust established for the afterbirth. There already is one. I know it's nonsense. I know the afterbirth is waste material. But they did it. They're using that DNA, that object, to give rise to a potential trust that you agree to when you walk into the courtroom. There is no trust. You create it. Look at this. Page 991 still. Organize, to establish or furnish with organs. To systematize, to put into working order, to arrange in order for the normal exercise of its appropriate functions. You know what? It says to establish or furnish with organs. I'm going to try not to run out of time tonight, but I'm going to go to the word organ real quick in Webster's. I just want to see what they say about the word organ. So, in the meantime, go ahead and talk amongst yourselves. That was a joke, obviously. So, let's see. Organ. O-R-G-A-N. Definition. part of an organism that is typically self-contained and has a specific vital function, such as the heart or liver in humans. Of course, the other one is the large musical instrument having rows of tuned pipes, but that's a different kind of organ. Let's go to Webster's real quick, see what Webster says about an organ. I find it interesting that they use the word organ donor on the back of a driver's license. Organ. A differentiated structure as a heart, kidney, leaf, or stem consisting of cells and tissues and performing some specific function in an organism. You know what? The placenta is such an organ. Now, I tell people I never use the word placenta. I always use the word afterbirth, but I'm now being very specific when it comes to placenta. A differentiated structure consisting of cells and tissues and performing some specific function. Bodily parts performing a function or cooperating in an activity. Organ. Okay, better keep going. Don't want to run out of time. So again, trusts are one of the major forms of organization for federal tax purposes, along with corporations, partnerships, and governmental units. I'm just going to ask you one last time. Which one of these four are you? Are you an organization? Are you a corporation, a partnership, or a governmental unit? Because those are the only four things that give rise to a trust. Which one are you? Well, the only one that you could be would be an organization, but then you would have to be parting yourself out through the afterbirth material. That's the only way you can participate in a trust. Okay, restatement definition. The restatement section of trust defines a trust generally as a fiduciary relationship with respect to property, subjecting the person by whom the title to the property is held to equitable duties to deal with the property for the benefit of another person, which arises as a result of a manifestation of an intention to create it. All right. It looks to me like they're presuming two separate persons here. What part of your life are you acting as a fiduciary over what other part of your life? Remember, it says a fiduciary relationship with respect to property. Subjecting the person by whom the title to the property is held, there's one person, to equitable duties to deal with the property for the benefit of another person. Now there's two persons. I hope you're starting to see a problem with this trust idea. Down below it says regs definition. An arrangement created either by will or inter vivos, which means living to living. Inter vivos means between the living people. An arrangement created either by will or inter vivos declaration, whereby trustees take title to property for the purpose of protecting and conserving it for the beneficiaries under the ordinary rules applied in chancery or probate court. I'm already confused. I can't imagine the moment I was born or any time thereafter since I'm still alive, why in the world any of my property would be involved in chancery or probate courts. Generally speaking, an arrangement will be treated as a trust under the Internal Revenue Code if it can be shown that the purpose of the arrangement is to vest in trustees' responsibility for the protection and conservation of property for beneficiaries. There it is, two separate positions again, a trustee and a beneficiary who cannot share in the discharge of this responsibility and therefore are not associates in joint enterprise for the conduct of business for profit. Which one of the two afterbirth positions has any mobility? I mean, does the fetal tissue have any way to move or do anything for itself? Does it have any capacity whatsoever? How about the maternal afterbirth? These are your two siblings. You have the brother, i.e. the chorion. There's one sibling there that they're calling it a sibling, by the way. Remember, the born alive material is a person, a legal person. I see it as three births. I see baby or genuine article or genuine baby. Then I see the chorion as being your brother. Your brother. Remember, it came from the zygote, so it came from your mom and dad. The chorion is your defective brother. But the chorion is also the same DNA as you, so it came from the same mother and father. So there's that child. And then, of course, there's the maternal afterbirth that doesn't have your father because it doesn't have any of his genetic material. So it has your mother, but not your father. So that's a half-sister. I went over that probably 3 weeks ago. So there's three siblings here. There's genuine baby, the only one that actually is legitimate. And then you have the chorion or the fetal tissue, which is your brother. In other words, this is a fraternal organization, is it not? And then you have the maternal DNA, which is female only, it only comes from mother. So you're sharing the same mother here, but you don't have the same father because the maternal afterbirth has no biological father. Three siblings. There's baby, and then there's the two born alive legal persons. I'm seeing a trust coming up. Here comes the trust. Three different positions. It's sickening that we would fall for it. See, the moment everybody learns that a trust cannot exist unless there's more than one position, there has to be more than one claimant. And my question until the day I die, really die, is how many people have a legitimate claim upon my life? Only me. Differences. The regulations emphasize the non-business character of the activity. Thus, a trust for state law purposes may be treated as a corporation or partnership for federal tax purposes. It says here it is. Shit, it's everywhere, people. Bullet point. However, both definitions emphasize a relationship among several parties. There has to be more than one. What is the word? What is several parties? What is several? Page 1232. Several. 1232. Several. More than two. Often used to designate a number greater than one. Holy cow. Does that mean that there has to be more than one in order to have a trust? Imagine that. It goes on to say, each particular or a small number taken or singly taken. Separate, individual, independent, severable. In this sense, the word is distinguished from joint. Several actions, where a separate and distinct action is brought against each of two or more persons who are all liable to the plaintiff in respect to the same subject matter. The same subject matter. The matter is the DNA, the subject is the title, is the name. Right now, I see three positions that could claim Curtis Richard Kallenbach. Genuine baby, chorion, and maternal afterbirth. Three potential claimants, two of which are a total farce, two of which are waste material, but two of which are potentially community property, cultural property. Uh-oh. Let's keep going. Who are the parties to a trust? Trusts are defined in terms of parties, grantor, trustee, beneficiary, and relationships pertaining to the trust property. trust property. Trust property. That's almost, from my position as a single man laying claim to his life, the word trust property, I can't even envision it being a part of my life. Grantor. Every express trust has one or more grantors who contribute the property to the trustee and state the terms of the trust. The grantor is deemed a substantial contributor and disqualified person with respect to the trust. Look at that. So somebody that grants the trust is disqualified with respect to the trust. How can I give a piece of me? How can I give any of my property away? I'm talking about my life here, either my name or my DNA. That's all I'm claiming. I'm only claiming my life, which is my industrial property, which is my capital labor and genetic material. That's all I'm claiming. It says other names for the grantor include creator, donor, founder, settler, truster. So if I don't want anything to do with the creation of a trust, then I cannot be a trustor, settler, founder, donor, or creator. If I use any one of those terms, the trust is presumed to exist. Trustee. The trustee or trustees receive the property and hold it for the benefit of one or more of the beneficiaries. The trustee is the legal owner of the property, but must use it for the benefit of the beneficiaries. As a fiduciary, he owes the beneficiaries duties of loyalty and care. Bullet point 2, the trustee may be an individual or organization. Wow, that's pretty amazing, because I know I'm not an organization other than, trillions of cells organized to keep me alive in my realm, in other words, my physical body. But it says the trustee may be an individual or organization. Trust companies and banks specialize in acting as trustees in addition to conducting banking and loan business. The grantor and trustee ordinarily may be the same person and may create the trust by declaring that he holds certain property in trust. The sole trustee and sole beneficiary may not be identical. So the trustee is the legal owner of the property. But the beneficiary and the trustee can't be the same. So as beneficiary, you cannot be legal owner of the property. There's your split again, people. I call it split personality. Me and Joseph were laughing about split personality earlier this morning. So it says the sole trustee and sole beneficiary may not be identical. Wow. That makes me really think. It says it may not be identical. Holy cow. Let me think about this for a second. I'm drawing this out right now. There's baby, there's mini-me, in other words, the chorion, and then there's the maternal afterbirth. Well, let me tell you something, people. The baby and the fetal tissue are identical. They are identical, absolutely identical. Same DNA all the way. They came from the same genetic material, which is the zygote. But the maternal afterbirth is not identical. Wow, there's your two positions right there. So it says the sole trustee and sole beneficiary may not be identical. I just identified now the two potential positions. There is baby and fetal tissue, and then there is the maternal afterbirth, two separate positions right there. Holy cow. As I live and breathe, as I speak, I just figured this out. Wow. To me, it looks like that, and of course, then the maternal afterbirth, because it's not your property. But it's oh man, I'm not going to go into that yet. Can you imagine that now? The maternal afterbirth as beneficiary. So the name Curtis Richard Kalamak is going to now benefit the maternal afterbirth, which is community property. It's cultural property. That means everything I ever earned through the name or title, Curtis Richard Kalamak, goes into the community chest or community property. I get to keep nothing. If the trust exists. Beneficiary. Oh, wait a minute. Let me finish that last. So it says the sole trustee and sole beneficiary. By the way, I think what they do is they make the baby and fetal tissue the trustee, and they give the beneficiary position to the maternal afterbirth. I'm writing this down for my own posterity here. I know that's the way it works. And now the state gets to claim all your property as the usufruct. Anyway, so here we go. The sole trustee and sole beneficiary may not be identical. Identical. Because the purpose of a trust is to separate the legal and equitable interest. Beneficiary. The beneficiary, also known as the Wk5 trust. The beneficiary is the Wk5 trust. Is the beneficial or equitable owner of the property. That's how you lose everything, people, right there. That's how you lose everything, right there. The beneficiary is said to have the use of the property and can appeal to the court for an accounting or replacement of the trustee to ensure proper use of the property. Man, we don't even have any control at all over our lives. At all. And doesn't it feel that way? You know what I'm going to do before next week is I'm going to draw what I just drew on my paper regarding this position right here, the grantor trustee stuff. I'm going to draw that so you can see how simple this is, and you're also going to see why we end up as the trustee. We have all the responsibility, all the duties, all this other stuff, and they, the state, then through the maternal afterbirth becomes the beneficiary to everything we do. Okay, let's keep going. Who are the parties to a trust? It says property. Alternative names for the property transferred to the trust. The property transferred to the trust. There are 5 bullet points here. Capital, corpus, estate, principal, and res. That's the property that's transferred to the trust. Always be thinking, by the way, of those positions, that whole birth situation, what goes on, what's created, what is generated at that birth event. Well, genuine baby, fetal tissue, maternal tissue, a title, and then a registered entity. There's at least 5 that I can think of off the top of my head. And so it says alternative names for the property transferred to the trust are capital, corpus, estate, principal, and res. I'm going to just do real quickly each one of these capitals on page 189. I don't want to do too much on these. I just want you to know what they are. Capital, 189. Remember, industrial property is capital and labor, by the way. So 189, capital. Accumulated goods, possessions, and assets used for the production of profits and wealth. So in other words, they're keying on the idea of production, product, produce, productivity. And it says owner's equity in a business. But anyway, production. Corpus, page 310. 310. Corpus, body, an aggregate or mass of men, laws, or articles. Articles. Physical substance, as distinguished from intellectual conception. The main body or principle of a trust. But it says physical substance. If it's physical substance, can it be the title? No, that's intellectual. So the corpus is physical substance. That sounds like DNA to me. Sounds like matter, M-A-T-T-E-R. Sounds like material issue. Okay, corpus. Estate, page 490. 490. I'm going to try to get through this tonight, and then I'm going to try to recap. Estate. The degree, quantity, nature, and extent of interest which a person has in real and personal property. That's a separation right there. Remember, real estate is both personal property or the title tied to the land. An estate in land tenements and hereditaments signify such interest as the tenant has therein. The condition or circumstance in which the owner stands with regard to his property. The total property of whatever kind that is owned by a decedent prior to the distribution. By the way, is there a decedent in your life? Should the word decedent ever come up when you're speaking about you or your property? Ever. Is there a decedent in your life regarding you? Well, the afterbirth, both the fetal and the maternal, are both considered decedents. Principle, page 1073. I want to get through this stuff so I can recap, because that's where it's all going to come together. 1073. Principle. That's Principal. Noun. The source of authority or right. The source of authority or right. You know, I never thought of it, but let's go to source real quick. The source of authority or right. Source. I'm going to go to source. Didn't have it written down, but I think it's important. Source. Source. That from which any act, movement, information, or effect proceeds. Holy shit. The zygote. The first of its kind. The very first cause of everything. Everything is subsequent to the zygote. Here we go. Source. That from which any act, movement, information, or effect proceeds. Everything follows the zygote. The zygote is the source of everything. It's the alpha moment in time. It's the beginning. It's the point in time and space that you began. You began. Let's go back to what it says here. Principle. The source of authority or right. Property. Principle. property, the source of authority or right, if the zygote is the source of authority or right, and a piece of the zygote called chorion or fetal tissue that is left behind in the afterbirth, is it possible that somebody could actually be claiming the source of authority or right in your life because of the afterbirth chorion or fetal tissue? You better believe it could be, because that is the beginning. The only way for you to claim it is by claiming your position, the living man, which pulls that concept, that left behind fetal tissue out of the afterbirth as waste material. The moment you do Minnesota Rule 220, you're claiming your position. You're claiming the source. You're claiming it. It's an a priori claim. And finally, res, R-E-S, page 1172. 1172. Res, the subject matter of a trust or will. Res is everything. Well, first of all, it says in civil law, a thing, an object. As a term of law, the word has a very wide and extensive signification, including not only things which are objects of property, but also such as are not capable of individual ownership. Oh my God, does it say that? Also such as are not capable of individual ownership. It says res is everything that may form an object of rights and includes an object, subject matter, or status. Remember, where does status come from? Status comes from the Father. Status and standing come from the Father. Does the maternal afterbirth have a father? No. There's no standing, no status for the maternal afterbirth. There is no father to that material. Res is everything that may form an object of rights and includes an object, subject matter, or status. Wow. Okay, so those are the different forms of property. But, again, which one of those things did you give up? Which one of those things did you knowingly, and with intent, put in the public pool? Which one of them? All of them? None of them? Maybe you should ask your evil twin whether he did. It says, can a trust exist without assets? Interesting. Assets required. By definition, a trust is a legal relationship with regard to property. Thus, the common law rule is that a trust does not exist without a res. So what piece of property in your life, what did you do to create the trust? What did you do to participate in this glorious cess decay? What did you put in there? Your right foot? Oh, no, wait a minute. That was a hokey pokey. Maybe you did put your right foot in there. Once they inked it and put it on a piece of paper. No, then you put your left foot in right after that. Now you have both feet in. Boy, I know there's a lot of little pieces of paper out there with both little baby feet imprints. Wonder if they call the baby footprint a seal. I know that the image of a foot is called a last. I'm not going to go. Anyway, assets required. A trust does not exist without a res. And again, back to res on page 1172. The subject matter of a trust. Res is everything that may form an object of rights and includes an object, subject matter, or status. You can read all about res. It's a really, really important word to know. By the way, you may have heard this term res judicata, a matter adjudged, a thing judicially acted upon or decided, a thing or matter settled by judgment. By the way, that's what they did with the afterbirth. That matter was settled. They're saying that it exists. They gave it a born alive status and legal personhood. They're saying it's settled. I'm calling bullshit. I'm calling bullshit. Assets required. A charitable trust may be created by a transfer inter vivos or by will. Inter vivos, again, is amongst the living, between the living, or by will. By the way, what is will? If not everybody has seen those old and somewhat tired Season of Treasons. In Season of Treason 3, probably around 2012, I talked about will. I talked about what will is. How can you describe will? Most people think a will is some piece of paper that, you wrote down saying, I want my bicycle to go to my younger brother when I die. A will is actually conduct. Will is conduct. The concept of will. Listen, I did this back in 2012, but will has to be proven. So if I desire, if it is my will to have my driveway clear of snow, the only way I can prove that will, that desire, is to go pick up a shovel and shovel the driveway. The cleared away snow, the driveway devoid of snow, now is a testament of my will. Will is a verb that's acted upon, just like love is a verb acted upon. So a will isn't a piece of paper, it's somebody's desire for an action. What's going to be done when I'm dead? Because I can't do it. Otherwise, I would do it. So again, back to the concept of the driveway full of snow. If I say that it's my will to have the snow removed from my driveway, but I sit upstairs and do nothing all day long, is it really my will to have the driveway devoid of snow, cleared away of snow? Hell no. There's no evidence that it's my will until I pick up a shovel and go do it. And then the testament of my will is the clean driveway. It is not my will to have the driveway cleaned off. So by the same token, if I show up in court, by that very conduct, is it my will to be there? Well, hell yes. My conduct proves it. The fact that I'm sitting there, it's my will to be in that courtroom. If it weren't my will, I wouldn't be there. Don't be confused about these ridiculous words. A will is an action. It's a desire acted upon. And until it's acted upon, until it is acted upon, it's not a will. Because something that if you really have a desire or a will to do something, you'll do it. If you don't have a desire to do it, you won't do it because it's not your will to do it. Holy cow. Did I really do all that just now? All right. A charitable trust may be created by a transfer, inter vivos, or by will by the owner or a person with the power of appointment. Now look at that. If there's a person with the power of appointment, that automatically presumes of trust. It says a charitable trust may be created by a transfer, inter vivos, or by will by the owner. So the owner actually has to create the trust. He has to do something. The trust doesn't exist until he does something. Alternatively, the owner may simply declare, look, he's still doing something, may simply declare that he holds his property upon a charitable trust. No transfer of title is necessary. He's still declaring it. Again, another action. A promise to transfer property to a trustee does not create a trust. A promise to transfer property to the trustee does not create a trust unless the promise is enforceable as a contract. Now you're talking piece of paper or a handshake that has been witnessed. Finally, it says a trust that lists no assets should be required to cite the proper state law that did blah, blah, blah. Who cares about that crap? All right, let's keep going. Can a trust exist without a trustee? Trustees may die, resign, become incompetent. But look at this. Can trusts exist without a trustee? My whole argument is, I don't give a shit. I'm not going to create a trust with my property. But it says, trustees may die, resign, become incompetent, or be removed by trust, or removed as trustee by the court for cause, i.e. mismanagement. If a trust loses its trustees, the court will appoint others, a court-appointed attorney. A trust will not fail for lack of a trustee unless the settlor manifests a contrary intent. What is a settlor? Let's go to that real quick. A settlor. The settlor is the original owner of property. I'm taking this out of Textbook on Trust, Paul Todd and Sarah Wilson. The settlor is the original owner of the property. So that's the settlor right there. Unless the settlor manifests a contrary intent. Manifest a contrary intent? That's called a will. That's all that is. He manifests it. He physically acts upon something. He shows it. It's his conduct. Unless the owner, the original owner, through his conduct, manifests a contrary intent. Hey, hell no. Hell no. No trust. By your very conduct, you're saying no. Unless the settlor manifests a contrary intent. Jesus, people. Look at the language you're using. It says, similarly, if a transfer of property to trust is ineffective only because no trustee is named in the instrument of conveyance, or the trustee is dead or incapable of taking title, like as an infant or somebody that's under the age of majority, a charitable trust is created. Oh, there it is right there. So the courts actually create this crap when you haven't reached the age of majority. How do you reach the age of majority? Minnesota Rule 220. So if you have not done a Minnesota 220, you have never reached the age of majority. People think the age of majority is chronological. It is not. It's majority. It's physical numbers. Remember, there's baby, there's chorion, and there's maternal. Those are three different positions, each having 33 1/3%. So if you're only acting as the baby or the infant, that's only 33 1/3%. And if there's somebody else acting upon the afterbirth collectively, well, then they have chorion and they have maternal. They have 66 2/3%. You're outvoted. So a charitable trust is created right there and then, and you lose everything. You lose all your power, all your property, all your authority, right there and then, just like that. Bullet point says, if a trust loses all of its trustees during the application process, the determination specialist. I wonder what the determination specialist is actually called. Is he wearing a black robe, I wonder? The determination specialist should ordinarily wait until the new trustees are appointed before recognizing exemption to ensure that the trust will in fact continue. It's all about the trust, people. That trust has to exist in that courtroom because that's the only way that they could draw from the fund. Remember, the fund doesn't exist or it does exist, but they can't. You need two keys to that safety deposit box called trust fund or trust. You need both the father's side and the mother's side. There's two keys to the safety deposit box called trust or fund. They need you to be incapacitated so they can grab up your key, and then they can go and raid the coffers on their end. And they call it management fees or whatever they want to call it. Also, as discussed below, the number and identity of the trustee should be a material factor in determining whether the trust serves a private interest. How many trustees are required? A single trustee is all that is required of trust under some state law. Under state law, although a typical arrangement for a charitable trust is a governing board of several trustees that makes decisions by majority rule. Several trustees, okay, baby, chorion, and maternal. Three different trustee positions. And, of course, they have to make decisions by majority rule. So baby by himself is 1/3. Can he ever win? Ever? No, because the other two always vote collectively. So they win by majority rule right there. It says a 501c3 organization is not precluded from exemption merely because the creator of the organization, if a trust, is either the sole or controlling trustee, or merely because the organization is controlled by one individual. By the way, just remember, mere is always mother or always mom. It says, but not recommended. In the case of a single trustee organization claiming public charity status, however, the lack of oversight inherent in such situation is a very unfavorable fact. Here it is. Sole corporate trustees are less objectionable, except where the trustee plans to do, here it is, except where the trustee plans to do business with itself or related entities with the trust's funds. Let's go to alter ego real quick in Black's, that's page 71. It says, except where the trustee plans to do business with itself. Wow, that sounds like a self-serving thing where maybe the trustee could get into trouble. Alter ego, page 71, Black's Law. Alter ego, second self. Under doctrine of alter ego, the court merely disregards corporate entity and holds individual responsible for acts knowingly and intentionally done in the name of corporation. To establish the alter ego doctrine, it must be shown that the stockholders disregarded the entity of the corporation, made corporation a mere conduit for the transaction of their own private business, and that the separate individualities of the corporation and its stockholders in fact cease to exist. That's what they're doing in the courtroom too. They're getting you to act, as a trustee. It's almost like you're stealing from the company, stealing from the trust, embezzling. As a trustee, you're embezzling funds, using it for yourself, personal gain. It simply fastens liability on the individual who uses the corporation merely as an instrumentality in conducting his own personal business, and that liability springs from fraud perpetrated not on the corporation, but on third persons dealing with the corporation. Third persons. Remember, there's three: baby, fetal, or chorion, same word, or maternal. So it says, except where trustees plans to do business with itself or related entities with the trust funds. That's called the alter ego, or second self. And then it says a large community-based board of trustees. Wow, this is going to be horrifying to me. A large community-based board of trustees is a favorable fact in determining whether the trust is operated exclusively for charitable purposes and is publicly supported. I call that the public pool, the public DNA pool. And it says community-based. Remember, the base or the foundation. We're talking DNA again. We're talking grounds. But it says community-based. I call that the public pool. Public, let's go to pool. The word P-O-O-L on page 1044. 1044. Pool. Now, why is the word pool in Black's Law? 1044. Huh, really? A combination of persons or corporations engaged in the same business, or for the purpose of engaging in a particular business or commercial or speculative venture where all contribute to a common fund or place their holdings of a given stock or other security in the hands and control of a managing member or committee with the object of eliminating competition as between the several members. Look at, it's funny how with the concept of split personality, baby, chorion, and maternal, 3 siblings, all fighting over the same property, all fighting over the same title, all fighting over the same fruits, usufruct. When in reality, there's only one, and it's the genuine baby. They've created the potential for a trust, and we buy into that shit. Because we listen to the moron in front of us. Like the lemming jumping over the cliff. We follow that lemming right in front of it that was standing there. I mean, he might have sounded pretty smart, but he's a jackass, a fool, leading people over the edge. There is no trust when there's a singular owner. It doesn't feel like a monopoly. It goes on to say, competition is between several members of the pool or of establishing a monopoly or controlling prices or rates by the weight and power of their combined capital. We already went over capital earlier tonight. Or of raising or depressing prices on the stock market, or simply with a view to successful conduct of an enterprise too great for the capital of any member individually, and on an agreement for the division of profits or losses among the members equally, or either equally or pro rata. Wow. Community-based board of trustees. That's you know, it's the public pool where I won't swim. Does a trust have to be registered with the state? No state filing. Unlike corporations, LLCs, or limited partnerships, trusts generally do not file their governing instrument with the state to become legal. However, a will that includes a testamentary trust is filed with the court as part of the will probate process. You know, I just noticed something here. It says, however, a will that includes a testamentary trust is filed with the court. Remember, will is conduct. Anyway, bullet point 1, it says, a few states have adopted the Uniform Probate Code, which requires the trustees of all trusts to register in the court of the principal place of administration of the trust. Register in the court of the principal place of administration of the trust. The trust instrument usually indicates the state law under which the trust is organized. If it doesn't, the determination specialist. The determination specialist. I wonder if that's in Black's. I doubt it. I mean, maybe it said. Maybe if you looked up judge, it might say determination specialist. I don't know. Let me see if the word determine is even in here. I think it's just such a funny word. It's like surface engineer, you know, for a floor sweep. Determination specialist. Let's see. Determine. Determinate. Determination. The decision of a court. Look at that. A determination specialist should ascertain the state law. Look what the word determination means. It says the decision of a court or administrative agency. So to me, just by looking at the word determination and then combining it with the concept of determination specialist, it says the decision of a court or administrative agency. So the determination specialist is either the court itself or the judge within the court or administrative agency within that court. A determination specialist. And it also says determination is the ending or expiration of an estate or interest in property, or of a right, power, or authority. So a determination specialist is also letting everybody know the ending or expiration of an estate or interest in property, or of a right, power, or authority, coming to an end in any way whatever. So the determination specialist sounds like a pretty powerful individual. And it finally says, like other nonprofit organizations, trust must keep orderly financial books and records and minutes of meetings and decisions, resolutions by their trustees. That sounds like the court itself to me. The whole court system, books, records, and minutes. That's what it sounds like to me. I'm going to skip over when does the trust begin to exist. It says, how are courts involved in a regulation of trusts? A trustee, particularly of a testamentary trust, may need to go to court to change the trust terms in order to comply. Courts will permit a reformation, a reformation, if compliance with the original terms is impossible, illegal, or would substantially impair the accomplishment of the purposes of the trust. What's really tough for me as I go over this is that I'm fairly certain that without a trust being generated or us participating in a trust at all, we don't end up in that courtroom, ever. It says examiners and determination specialists should be aware of this possible requirement when asking trustees to make changes in the trust document. Other court proceedings. Courts are involved in the administration of trusts in many other ways. Trustees may be required to account to the court for their administration of the trust, both periodically and upon termination. Beneficiaries may sue for an accounting or to replace a trustee. A beneficiary. Again, early in this call, I decided that the beneficiary is the maternal afterbirth position. And isn't it funny how the state of Illinois is always bringing a charge or a cause of action against me? Why? Because the maternal afterbirth is community property, or what I call cultural property. So Illinois has its own cultural property, and they're saying that I'm infringing or I'm trespassing on their property if I'm found using it out there on the commercial seas by, I don't know, a cop. It says the trustee may voluntarily account to the court for the court's approval of the trustee's own protection. Man, I tell you. Trustees may bring legal proceedings to receive instructions from the court. Trustees may bring legal proceedings to receive instructions from the court on the proper course of action. Sometimes it seems like they're telling me what to do, but what they're saying is I'm asking them to please tell me what to do. This is interesting here, too. It says down here, it says chancery. Legal proceedings involving the administration of trusts are usually proceedings in chancery. Wow. The very first bullet point here, it says trusts, comma, with their separation of legal and equitable property interests. God, how many times do I have to say that there is a split, multiple claimants, at least more than one. And my question will never, ever change. How many people have a legitimate claim upon your life or the product of your life? In other words, how many people can make a claim upon the industrial property of your existence, meaning your capital, your labor, or your genetics? How many people are you willing to give a share in your capital, your labor, or your genetics? Trusts, with their separation of legal and equitable property interests, arose under English law. It says, with their separation. Page 1224, separation. Let's just see what it says there. I mean, we all know what separation means, right? 1224. Separation. Separate, individual, distinct, particular, disconnected, generally used in law as opposed to joint, though the more usual antithesis of the latter term is several. Either of these words implies division, distribution, disconnection, or aloofness. Separate estate, the individual property of one of two persons who stand in marital or business relation as distinguished from that which they own jointly or are jointly interested in. Separate property, separate property. Property owned by married person in his or own right during marriage. The real and personal property, including wages and earnings of a woman, which she owns at the time of her marriage, and the real and personal property and the rents, issues, and profits thereof. Community property. This might be interesting. In a community property jurisdiction, separate property is that property which belongs entirely to one of the spouses. Generally, it is property acquired before marriage and acquired after marriage by gift or inheritance. For the purposes of community property settlement, separate property is that which either party brings into the marriage, acquires during the marriage with separate funds, or receives by inheritance. Again, in community property jurisdiction, separate property is that property which belongs entirely to one of the spouses. Entirely. Keep going. Look at that. How are courts involved in the regulation of trust continued? Chancery continued. By statute, the state court of jurisdiction for trust is often a special court known as probate, surrogate, or orphans court. Why would that be? Probate, surrogate, or orphans court. Let's look at probate real quick. Let's just see what it says. Probate. Okay. Probate court. A court having general powers over probate of wills, administration of estates, and in some states empowered to appoint guardians or approve the adoption of minors. Probate jurisdiction, the exercise of the ordinary, generally understood power of a probate surrogate or orphans court, which includes the establishment of wills, settlement of decedents' estates, well, I'm not dead yet, supervision of guardianship of infants, well, I'm not an infant, control of their property, and other powers and functions pertaining to such subjects. I don't know how I could even be involved in a probate jurisdiction. Probation. The evidence which proves a thing. Probation. The evidence which proves a thing. probation. The evidence which proves a thing. If I don't claim the birth record, if I don't claim that moment in time, if I don't claim that position as me, solely, exclusively, I'm not here. Minnesota Rule 220 is you proving or making a claim upon that document with that record as yours. Remember, we can't ever testify for our own benefit regarding our arrival here. That's hearsay. It doesn't work that way. Again, probate, surrogate, or orphans court, that's chancery. And remember, chancery is the ones handling these trusts. So let's see what surrogate says. By the way, there's lots of movies out there regarding surrogates. That's an interesting concept all by itself. Surrogate. 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 The name given in some of the states to the judge or judicial officer who has jurisdiction over the administration of probate matters, guardianships, etc. Matters. Probate matters. Is your physical body, the one that I'm speaking to right now, that's receiving this information right now, is that physical body a matter? Is it a matter of fact? Of course it is. You exist. But is it a probate matter as defined by the probate? Are you a minor? Are you dead? Are you a decedent? Are you an orphan? Maybe. Probate matters, guardians. In other states, he is called the judge of probate register. So a surrogate can also be called a register. Judge of the orphans court, etc. He is ordinarily a county officer with a local jurisdiction limited to his county. Surrogate court, name of the court in certain states, which jurisdiction similar to that of the probate court. Surrogate. The name given in some of the states to the judge or judicial officer who has jurisdiction over the administration of probate matters or guardianships. That doesn't sound like me. Why would my stuff end up in a surrogate or probate situation? Well, what about orphans court? Now that seems pretty obvious. I'm not an orphan. But you know what? The afterbirth is, it's called a foundling child. Orphan. So the orphans court are dealing with the foundlings, the left behind material. Orphan. Orphan. All right. Any person, but particularly a minor or infant, who has lost both or sometimes one of his or her parents. I think the ultimate orphan is the maternal afterbirth, because that's the one that never has a father to begin with. Never has a father. At least not an earthly father. One of his or her parents. Okay. Keep going. So chancery. By statute, the state court of jurisdiction for trust is often a special court known as, so it says often a special court known as probate, surrogate, or orphans court. It says these courts have jurisdiction over probate of wills and administration of trusts and estates, as well as cases involving guardianships and minors. Can a trust exist without beneficiaries? Now, by the way, I love when you use the word X, but it says, suppose a charitable trust is established to benefit X hospital and has no contingency plan if X hospital goes out of existence. Suppose X hospital goes out of business. What was the trust? Was the trust charitable initially? Is the trustee now required to terminate the trust and return the property to the grantor? I don't care about any of this stuff because, again, it presumes too much. Okay. Can a trust exist without a written document? Express versus implied trust. Yes, but it will not pass the 501c3 organizational test. An express trust, also known as a direct, technical, or voluntary trust, is declared in express terms, either oral or written. In other words, conduct. Kurt Kallenbach, here, Your Honor, by the grantor. Implied trusts, including constructive or involuntary trust and resulting trust, are equitable remedies imposed by courts to prevent unjust enrichment. And a court may impose a constructive trust upon the holder of property acquired through fraud, mistake, or undue influence. Okay, look at. If Curtis Richard Kallenbach, if I never made a claim on it, if I never made a claim on my own life or my property, and I'm now using Curtis Richard Kallenbach in all my businesses, right now any court could come in and say, that's not my name, that's not my title, that's not my property. So a court may impose a constructive trust upon the holder of the property acquired through fraud, mistake, or undue influence. Fraud, mistake. They may not call it fraud, but they certainly could call it a mistake. But either way, I shouldn't be dealing with that property. Document title. A written document governing the trust typically is given one of the following titles, although no title is necessary: an agreement, declaration, a deed, indenture, instrument, or will and testament. I'm going to see if there's anything else that really looks interesting to me. I mean, that we can cover in the short period of time that we have left. How about, we only have about 20 minutes left. Let's go to, what is a community trust? It's about 6 pages further along. I'm going to go to the word community before I do this. Let's go to the word community. 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 This is pretty funny when you look at it. Community property, we already kind of covered that. Community, a neighborhood, a vicinity, synonymous with locality. People who reside in a locality in more or less proximity. It's funny how they use the word reside as in residence. Goes on to say a society or body of people living in the same place under the same laws and regulations who have common rights, privileges, or interests. That's so huge to me. Common interests. To me, that's common ground. And that's the public pool. That's the giant Frankenstein monster. The beast. It says it connotes a congeries of common interest arising from associations, social, business, religious, governmental, scholastic, and recreational. A society or body of people living in the same place under the same laws and regulations who have common rights, privileges, and interests. Neighborhood, vicinity, locality. So community, kind of publicly supported organization. Community trusts typically qualify for exemption under, it says a community trust is the term used in the regulations defining publicly supported organizations. A community trust historically, now we're into the concept of what? Cultural property. A community trust historically is a group of separate trusts or funds subject to some control by a governing body of community representatives. Subject to some control by a governing body of community representatives with a purpose to collect, invest, and distribute funds for the benefit of the community. With a purpose to collect. Does that sound like you filling out an IRS 1040? Who's collecting for whom? Are you the collection agent for the IRS? Is that a capacity that you have while participating in the community trust? I say yes. I say that you are actually acting as a collection agent for the IRS. Again, it says a community trust historically is a group of separate trusts or funds. Remember, every one of us with these birth certificated after-birth positions have our own separate trust. It says a group of separate trusts or funds subject to some control by a governing body of community representatives with a purpose to collect, invest, and distribute funds for the benefit of the community. If the group of funds meets the applicable requirements, the group is treated as a single entity for tax purposes. I want to see what the word representative means real quick. Community representative. Community representative. Oh, here's first I want to go. It says community of interest because it does say. It's about combination or interest. Here it is. It's community of interest. Term as applied to relation of all joint adventure. Means interest common to both or all parties. That is, mixture or identity of interest in venture wherein each and all are reciprocally concerned and from which each and all derive material benefit and sustain a mutual responsibility. Look at this. The word mixture and identity of interest, it goes on to say derive material benefit. Think about the product or what is produced on that birthday, and how the material. And when I say material, I'm talking about the physical substance that comes out of mother's womb. That's the material I'm talking about, always. When I hear the word material in this context, it's always going to be the DNA. It's always going to be your physical existence. Baby has material, chorion has material, and mother has material, or the maternal afterbirth is material. It says derive material benefit, where it says from each and all derive material benefit and sustain a mutual responsibility. Remember, basically it's all the same. They're your brothers and sisters, or brother and sister. Here's down at the following page, it says private foundation status. If the trust does not qualify as a public charity, then it is treated as a private foundation for the purposes set forth above. But look at this. It says if the trust does not qualify. Again, it's the presumption that a trust exists that I struggle with. Will I ever be able to defeat the trust? I think so. I think I'm going to be able to break it up in my next letter. Because ultimately the trust itself, based upon the born alive or afterbirth material, which is the only way it could exist, it's the only way it could exist, by the way, it becomes what? Repugnant. The afterbirth material by itself, just even talking about it as far as being part of the birth record, is a repugnancy. Okay, next page. What is a split interest trust? Split interest trusts were treated at length in trust primer, whatever. Definition: a split interest trust is essentially a trust with both charitable and non-charitable beneficiaries. Really? So which one would be a charitable beneficiary? The Rain Man? The one that is institutionalized? The one that can't move, like the chorion or the maternal afterbirth, which I say has been institutionalized since day one, like Rain Man? A split interest trust is essentially a trust with both charitable and non-charitable beneficiaries. The term is a term of art referring to certain trusts described in and have both assets for which a charitable deduction was allowed for income, estate, or gift tax purposes, and unexpired non-charitable interest. Private foundation status again. Kinds of split interest trusts. There are two kinds of split interest trusts. Charitable remainder trusts, the most common. The most common? Charitable remainder trust, the most common. And charitable lead trust. A pooled income fund, which may be regarded as a kind of charitable remainder trust subject to its own special rules, is also subject to IRC. I want to go back to the word remainder real quick. Remains and remainder. Because remember, I believe that everything left behind or remaining in the hospital are the remains or remainders. Let's see what the remains. Remainder, the remnant of an estate in land depending upon a particular prior estate created at the same time and by the same instrument and limited to arise immediately on the determinant of that estate and not an abridgment of it. Oh my God. I'm going to go to remnant real quick. I'm running out of time. Remnant. Remnant. Remnant rule. The rule that width of lot, frontage of which is not specified on plat, specifying frontage of all other lots in the same block as length of block minus total width of other lots. I believe that in my estate, when you take all DNA into play, when you bring it all into one place, you got to think of my block, my estate as having 3 parcels to it. Baby is a parcel, chorion is a parcel, maternal afterbirth is a parcel. It's all part of the same birth event. That's how I look at it. And it's all under one title, and each one of those parcels has a claim to that title. But I'm going to look up remnant in Webster's real quick. Remnant. A usually small part, member or trace remaining. Does that sound like the afterbirth? Usually a small part, member or trace remaining. A small surviving group. An unsold or unused, remember the word abuse means unused, an unsold or unused end of piece of goods. End of piece of goods. Remnant. Back to remainder on page 1162. The remnant of an estate in land depending upon a particular prior estate created at the same time. Is that the zygote or what? The remnant of an estate in land depending on a particular prior estate, there's the zygote, created at the same time, you better believe it, because that fertilized egg, that fertilized ovum is the zygote, and the chorion is a remnant by the same instrument and limited to arise immediately on the determination of that estate and not in abridgment of it. Remainder. Remainder man, one who is entitled to the remainder of a estate after a particular estate carved out of it has expired. One who becomes entitled to estate after intervention of precedent estate or on termination by lapse of time of rights of precedent estate created at the same time. Listen, there are two positions from the chorion, or from the zygote. One who is entitled to the remainder of the estate after a particular estate carved out of it has expired. Which one of us has expired? Me or the chorion? You see, okay, let's keep going. I'm running out of time here. Again, a pooled income fund. I don't need to go over that. Can a split interest trust qualify? Matter of timing. Don't care about any of that stuff. Ultimately, this comes down to the concept of the trust itself. I believe, and I'm going to take the last 5 or 6 minutes here, and I'm going to go over this again. Mom lays with dad. The ovum is now fertilized by the sperm of my father. That product becomes the zygote of the first of my kind. In other words, one dad and one mom create a new one me. 1 + 1 = 3. Now, and I am completely separate and unique from my mother and father. I am neither my father's DNA or my mother's DNA. I'm a combination, a unique combination of their DNA. So I'm a separate entity completely. And that's the zygote. The zygote goes through its process, and at some point, a piece of the zygote splits off and forms part of the amnion and some other things. It's called the chorion. Mother carries this zygote after it goes into or adheres to the uteral wall, and she starts to build with her own DNA the vessel or the maternal product that is required. In other words, without my mom doing this, I don't survive. So my mom creates this other product that allows me to get to this new world. And that ends up being the maternal afterbirth. No father. It's my mom building all that structure herself. So mom walks into the hospital from the soil of Illinois, the Republic, walks into this hospital, this corporate position. Does she stop by customs and declare the package in her womb? No. She delivers the package in this other territory. Does she call customs right then and there and say, hey, listen, I got this baby boy here? No. They wrap up baby boy. My dad and mom leave the hospital. On their way out, do they stop by customs and say, listen, we're taking our newborn, we're declaring our baby, and we're going back to the Republic? Do they do that? No. So now there's no evidence, there's no record of baby boy, the genuine baby. As I go back into the Republic, there's no evidence. The only evidence of my existence was left behind in the hospital on some paperwork, signed by 3 witnesses. And that particular title, the title to that paperwork, happens to be Curtis Richard Kallenbach. Is that a name? No. Could it be considered literary property that was authored by somebody while they were staying overnight in that particular hospital or hotel, whatever you want to call it? Of course it could be. Could it be the new title to a manuscript, the story of somebody's life? Yes, it could be. The point is that Curtis Richard Kallenbach is not a name. It's never been considered a name. It's literary property or a title. That gets left behind or abandoned. What about the DNA, the other product that comes out of mother's womb that gets left behind as well? What does that consist of? Well, there's two parts to that. One part is fetal tissue, which has my DNA, which split off from the zygote early on. That's my DNA exactly. What other DNA is left behind? My mother's DNA, the maternal afterbirth. So there are three things left behind in the hospital after baby goes home. The title, the fetal tissue, which is my DNA, and the maternal tissue, which is my mother's DNA. Those three things are left behind in the hospital. Nobody goes back, ever claims them. They fall, I say it goes into a lost and found, which most people would refer to as a trust. And so that property is in the trust forever until I go back and lay claim to my position. When I lay claim to my position, is there a trust anymore? No. Was there ever really a trust? I don't think so. Because, first of all, was the succession of words, Curtis Richard Kallenbach, was it intended for me from the beginning? Well, here's the problem, is that by an a priori claim, the fact that the zygote existed prior to any other product, in other words, upon fertilization, that ovum, when it became the zygote and it differentiated into me, at that moment, everything that followed me, for me, is my property. So when my mom and dad decided on a succession of words called Curtis Richard Kallenbach, that is my title. It's not a name, but it's my property. And the DNA that was left behind is already my property. There's no discrepancy there. I even have a personal DNA profile done to make a legitimate claim upon the left behind DNA that matches me. But what about the maternal afterbirth that's left? That's my mother's DNA. Do I have a claim on that? Not really. Is it my property? No, it never was my property. Did my mom create it specifically for me? Well, of course she did. In fact, without the zygote, the maternal afterbirth doesn't exist at all. So she built that. She created that DNA specifically to get me here to this new realm. Is it my property, though? No. Do we share the same mother? Yes, the maternal afterbirth, according to the legal term born alive, is considered a legal person. Does that female DNA have the same mother? Of course, it's my mom. Does it have the same father? Well, no, it doesn't have any father because the maternal afterbirth was not generated by my father's sperm. It was not generated by my father's DNA. So the maternal afterbirth doesn't have a father. So we don't have the same father. No, we don't. So now what do we have there? We have three pieces, three things that realistically, two of them I can claim, but I can't claim the third one, which is the maternal afterbirth. So that could always be stuck in a trust. Realistically, the maternal afterbirth is not mine to claim, even though she built it specifically for me. I could probably make the argument that without me it wouldn't exist, which means I would have an a priori claim over all product that my mother generated for me to get here. But ultimately, my mom's DNA, my mom is the vessel that carried me to this new world. My mom herself is the vessel. So her DNA represents the vessel. The maternal afterbirth represents the vessel that got me here. In other words, the ship. So the ship itself that got me here, represented by my mother's DNA, basically crashed ashore after I disappeared. So they're looking at that as a shipwreck. And that shipwreck is probably property that got salvaged. So that shipwreck gets salvaged, and now because somebody brought that vessel back ashore, there's a lien against the owner of that ship. Is there a lien against my property? No. But there is a lien against the vessel, the ship itself, that was salvaged. So if there's a lien, it's going to be against the owner of the ship, which would be my mother, not me. Is any of my property at this point held in trust? No. Was it ever to be entrusted? Was it ever in the hands of anybody else? No, because I've always been alive. I've never been missing. I've always been alive. So has there ever been a legitimate trust for me? No. Was there ever a legitimate trust for my mother's property? Yes. That's my point. There is no trust for me. And when I make the legitimate claim upon my DNA, which is also tied to the title, Curtis Richard Kallenbach, that is why the Sedekevai Act of 1666 says, when a man proves life, he's revested with his title. The moment you prove life, the moment that name, Curtis Richard, or that title, Curtis Richard Kallenbach, is now in my possession, full possession, and anything ever earned through that title is mine. That's the story. So on that note, next week I'm going to actually be going over all the documents that I put together, why I put them together the way I did, and I'm just going to tell you right now that there is no trust, not for your property. There never was a trust for your property, and you need, and God forbid anybody considers going after some weird trust property, because you know what? The only thing that's ever been in that property, in that trust, is your mother's DNA. So it is a false claim by you even, until you do a Minnesota 220, everything you do is false or fictitious. But the moment you do a Minnesota Rule 220, your life is now in your hands. So on that note, I'm done for the night. But next Monday we'll reconvene. And we're going to be going over my documents, which I'm going to post up at pCloud probably tomorrow morning. So, good night, everybody. I am done.